Well, hey guys, welcome back. Welcome back. It's been a minute. It's been a minute. Hope everybody's having a fantastic summer. I gotta tell you guys, I'm enjoying this one a little bit more than maybe I should. But it's just having one of those years where I'm really feeling free for the first time in a long time, and yeah, just kind of taking the opportunity to dive into that a little bit. Just really enjoying the chance to get out, do different things, see different places. But you know, the world goes on. Cases continue, and here we are back with Karen Reed. Already back with Karen Reed. It's always kind of hard when a case is in limbo like this. I mean, first off, I feel enormously for Karen and her team because the whole process of going through trial, it's such a process, it's such a weight, and there's of course the expectation that one way or another, at least it's going to be resolved. At least you're going to have some kind of finality. You're going to know what you have to deal with, and you're going to be able to move forward. And so when you get a mistrial, it can just be crushing, even though the common wisdom, of course, the mistrial favors the defendant. It does. It's not a win for the Commonwealth. There's no conviction. The presumption of innocence still attaches, etc., all those reasons. But just from a pure psychological standpoint, it really can be very difficult because you have that expectation of we're almost through this. We can see the end of the road, and then all of a sudden it's like when you get over, you've been watching the top of that hill for like the last couple miles, and you finally get up there and you realize, oh, false summit. There's still all this way to go. So I do fully expect, though, that they're going to take complete advantage of the opportunity of all of the time that they now have. I don't expect them to sit idly. They're going to be using this opportunity to do what they can to improve their case, improve their position. And so the motion that we're looking at today, this is some kind of indication of that approach going forward. So I probably don't have to give you guys a whole lot of background about what's going on here, because it has, been out there circulating for quite some time. But I will go ahead and just give you the real broad overview. So we're here today on the defense's motion to dismiss counts 1 and 3. And the argument that the defense has made is that they were contacted by some jurors out of the blue who told them that in the jury room, the decision had been made unanimously to acquit Karen Reed of counts 1, the second-degree murder charge, and count 3, the leaving the scene of an accident, without stopping or providing your information or whatever, hit and run. That everyone agreed she was not guilty of these particular crimes, and the only one that they had a dispute about was count 2. The problem, of course, though, is that this was not formalized. There was no, verdict form signed, nothing returned, no affirmation of that in court, confirmation that that's the verdict. Judge Bev didn't ask them if they were able to reach a verdict on any counts, or if their inability, was universal. They didn't indicate, apparently, in any of their notes that they were able to reach agreement on anything at all. So it's a situation that's a little bit, murky from certainly a factual standpoint. And it just implicates a lot of other kinds of considerations about things like, remember that dispute, the whole dispute we had about the verdict forms? And the instructions themselves, the instructions that Judge Bev gave on how the jury was to conduct its deliberations and try to reach decisions about, you know, some or all of the charges, the process of filling out the verdict forms, all that type of thing. The instructions that Judge Bev gave were quite a bit different than the instructions that are the form that Massachusetts provides. Now, form instructions, they typically are not mandatory. It's just because they exist doesn't usually mean like you have to give that instruction. It's just that most people do because form instructions, they're typically created by committee, like committee of experts. Oftentimes it's judges on the appellate courts that are sitting on it, you know, attorney practitioners, just folks who have been following the case law. They understand what the requirements are. And so it's kind of a process of coming to consensus about really what is the best thing that we should expect to be able to instruct a jury on particular points. And so there's kind of an understanding. I mean, it's not that form instructions are never wrong. Form instructions are wrong, and they do get challenged and they do get struck down on occasion. So it's not like they're automatically right just because it's in the form. But there tends to be kind of a presumption. Like if you go on appeal and you're challenging a form instruction, like you're the underdog in that situation. There's really no question about it. You're going to be the one who's going to be expected to show what the problem is with this instruction and why it is an issue. So I say all of that again to just clarify that she's not required to give the form instruction. It's not against the law to not do that, but it does put you at a little bit of risk when you don't, because that form instruction has been at least vetted, and you go off script with whatever you think is appropriate. Well, you might be wrong because you're just one person with one opinion, and you haven't gone through that process of like checking your ideas against, you know, other informed colleagues and people who might be deciding this issue and stuff like that. So her instructions were quite a bit different than the form instruction. But there's still kind of a couple of problems with that because the defense didn't object to any of those instructions. Normally what happens, and it looks like what happened in this case, is that the instructions kind of get compiled throughout the course of the trial. And part of the reason is because you don't necessarily know what you're going to need until the evidence is done. Like, for example, there's usually a form instruction on the defendant choosing not to testify. Well, you don't know if you're going to need that one or not until after the defense is rested, because they can call the defendant to the stand at any point before the jury gets the verdict. So there's, you know, generally preliminary ones or like general ones that you know well in advance you're going to need, right? You know you're going to need the instructions on what are the elements of the crime. You know you're going to need the general instructions on how do you consider evidence and things like that. But as the trial goes on, you typically evaluate as you go, you know, what other ones you may need. So it's late in the day when typically there is a full set, like a draft set of jury instructions that's compiled. So the prosecutor may do that, the court may do that, the defense may do that. There's just different ways of doing that in different jurisdictions. In this jurisdiction, it looks like it's a combination of the judge does quite a bit, and then the parties propose instructions that are specifically what they want. So once that draft is compiled, then that is distributed to the parties. They have an opportunity to review it. And then you have what's called an instructions conference. And we did have an instructions conference in this case. We watched that as part of the hearing before the jury came in. And it's basically an opportunity where they go through what the instructions are going to be, and the parties have an opportunity to put on the record, do you object to any of these instructions being given? Do you accept from the judge's decision not to give an instruction that you have requested? So they take objections and exceptions on the record, and the judge will rule on those, and then based on that, you have your final jury instructions, and that's what's given. So in the instructions conference in this case, there weren't any objections raised to kind of the language of how she instructed the jury to consider the charges, to fill out the verdict forms and things like that. The problem with that then means that if it turns out those were a little bit confusing, that maybe, she used language that suggested the jury needed to reach a decision on all charges before they could do anything at all. The problem is that that's waived. If they don't raise the objection, it's waived. And so then there's only very, very narrow exceptions to be able to bring that up, typically on appeal or in a motion for a new trial or something like that. Very limited avenues to be able to bring that up. It's typically got to be the kind of error that is really obvious. It had a major effect, massive miscarriage of justice type of situation. And there just doesn't seem to be anything here that would really establish that. For one thing, I mean, if it's really clear, this is a little bit of a, paradox, but it's just they would have objected, right? If it was that obvious, these are smart lawyers, they would have objected. It's not a situation where like somebody was asleep at counsel table, or you've got other kinds of concerns about effectiveness of counsel or something like that. Really doesn't look like that type of a situation. So it's not an obvious error, and you do have to go through and kind of parse the language a little bit to see what the differences are, and then how material those differences are. Is it so substantially different that like it materially changed the meaning of the instructions? My reading on it, it didn't really. I mean, there were deviations, yes, and there was a possibility of confusion, but it wasn't like a situation where there was just an obviously wrong procedure laid out in those instructions. More of a situation where there's ambiguous language that can potentially be interpreted some different ways. And so you would normally expect and hope to sort that out in the instructions conference. If somebody sees it, they're like, don't really love how that's expressed. I'd rather say it this way. So the whole reason you have that conference is to be able to resolve those issues that are a little bit more, gray area, a little bit more closer to the mean of like what the instruction should be. So the jurors may have been confused about the instructions. There does seem to be some indication of that in the affidavits that the defense submitted. So the Commonwealth has responded, and the basic gist of their response is that this is not evidence you're allowed to consider. Jurors talking about the substance of their verdicts is not something that you are, it's not cognizable evidence. And on this point, legally speaking, the Commonwealth is in a very, very strong position. This is the law pretty much everywhere that I know of. I did go down the rabbit hole and look at it for Massachusetts. Massachusetts, it might even be stronger than in some other situations. So in my state, there's an exception. You can bring in a juror to testify about what happened in the jury room if what they're testifying about is misconduct. If they're there to show that, hey, the juror didn't follow the court's instructions, the verdict wasn't unanimous, some kind of fundamental defect like that, that indicates that some part of those rules and those instructions wasn't abided by. You can bring in a juror to testify about that in my state. And Massachusetts really doesn't look like they can. It really doesn't look like they can. It's extremely, extremely strict in terms of their limitation. There was some case law that I found that said that some examples of when they cannot, you can't ask, the judge can't ask, they cannot take juror testimony on issues of whether the jurors misunderstood the instructions, whether they were tricked into agreeing with the verdict. Tricked. Not allowed to take evidence on that. Evidence that they didn't follow the instructions. They committed misconduct. Maybe they nullified. In my state, nullification, no. If a juror comes in and tells me they literally said they weren't going to follow the law, they just wanted to find my client guilty or whatever, I can put that juror on the stand and get that in front of the jury, because nullification is misconduct in my state. I mean, probably in most states, because you're literally not following the instructions given. Not allowed in Massachusetts. And then the last one that I saw, a juror felt pressured by her fellow jurors to vote guilty. Somebody was pressured into voting guilty. They can't consider evidence on that. So not a good position for Karen Read to be in here, because clearly for her to establish this basis for relief that she's arguing, she has to rely on juror testimony, because they didn't sign a verdict form. They didn't send anything back. It didn't come to open court. They weren't asked at any point, were you able to reach a verdict on any of these charges or any part of the case? So that's all she has to go on. She has responded to this by trying to argue that we're not asking about the substance of the juror deliberations, right? We're not asking them, what did you say, or why did you reach this decision, or what sorts of disagreements were you having? So they're arguing it doesn't violate this rule. We're just asking for the result. And, a result, if it's got legal significance, then, that maybe is an exception to it. She didn't really have case law to support that, which is not particularly helpful. The problem they're going to run into there is that, once again, Massachusetts law is really not favorable to them on this point, because they make it very, very clear there's no verdict until the formalities of entering and accepting a verdict have been followed. A lot of this stuff, again, goes back to old common law. It's on the one hand, you can look at it as like, well, there's magic words, or there's like the spell that has to be cast, for the jurors' agreement to become something legally binding. And that can seem a little bit silly. It can seem very silly, right? If the requirement to return a verdict includes specific language that the court has to use, the clerk has to use to read the verdict into the record and things like that. Then if they fail to do that, there's no verdict. It sounds a lot like a form over substance issue. And, a lot of times potentially it could be. But the basic idea behind it is just that if you don't have those formalities in place, you don't necessarily have a total assurance that that decision is final. And so there were a couple cases about this that I looked at that to me were just like, I've never had this issue where the jury's agreed, behind the scene, but didn't return a verdict, and it implicates double jeopardy, right? The defense is square on right about that. Yes, double jeopardy is very much implicated by that. Because if they acquitted her, if she is acquitted of charges, that's literally what the double jeopardy charge is about. You don't get to take somebody back to court over and over and over again to try to get the conviction. You get one bite at the apple. And if the jury says, no, you haven't met your burden, that's it. That's the end of the road. So they're absolutely right that double jeopardy is implicated. The problem, though, is that decision and the nature of this decision. Because deliberation is a process, and it's often a negotiated process, right? We like to think that it's just everybody coming together to get on the same page and see everything the same way and reach a meeting of the minds and so forth. But the reality is, with 12 people, it's probably not happening. What you're getting is a lot of compromise. You're getting a lot of, people are polarized. Somebody is strongly in this position, somebody is strongly in this position. They don't agree on those fundamentals, but they also they want to do their job. They want to be able to return something. So there's a process of negotiating, really, and seeing, well, is there somewhere in the middle where we can land where we're all in agreement? If the jury has maybe a conditional agreement, yeah, if we look at manslaughter, we can all agree she's not guilty of second degree murder or something along those lines. It isn't necessarily a final decision. It's just part of that process of negotiation. And so that's why they have these formalities, to make sure there's a distinction between we said some things or we, put gambits out there, put proposals out there through the process of doing the negotiation, doing the deliberation, but never came to a point where that was, what we finally decided to do until those formalities are followed. And so in Massachusetts, the verdict has to be in writing. Okay, they have to complete the verdict form. It has to be presented, like read out in open court, and they have to acknowledge it in open court. So basically, they have an opportunity if somebody, somebody is in the bathroom while the rest of the holdout's in the bathroom while the rest of the jurors decide we're going to go ahead and fill out the form and send it back, right? And they're going to try to sneak it through or something like that. It gives the opportunity for that holdout in court to be like, wait a minute, I didn't vote on this. This isn't the verdict. And that would, prevent it from being final. So cases where this came up, I mean, they were kind of wild. The first one is this very early Massachusetts Supreme Court case from 1949. It was a civil case, and it involved a plane crash. So basically, two planes that are, and one of them is kind of like buzzing the other, something like that. Well, the plane that is being buzzed, it has a student pilot, and the student pilot at one point basically sees the other plane coming, freaks out, freezes, can't get out of the way, planes collide. There's an accident. So yeah, don't prank with planes, guys. Just don't prank with planes. Don't do it. It's not a good idea. If you read Catch-22, if anybody read Catch-22, it's one of my favorite books. There's a bad plane prank gone wrong in that one. Stakes are just maybe a little bit too high to be playing around with that kind of thing. Anyway, they have a trial. Goes through the evidence, goes to the jury. The jury is deliberating. They reach a verdict. They sign it. They seal it up in the jury room. Everybody's unanimous. Everybody agrees, but it's too late to go back into court to deal with it, basically. So they are going to come back in the morning. Well, that night, one of the jurors dies. So they get back the following morning, and the judge is thinking, well, we've only got 11 jurors left to affirm it, but clearly they had reached a final decision. They had done what was in their power to be able to formalize that. So with the attestation of the 11 remaining jurors, I'm going to go ahead and accept that verdict. And the Massachusetts Supreme Court reversed. They said, no, you have to have the consensus of all of the jurors on the record, the assent of all of the jurors on the record, or you have not met those requirements, those formalities of having a final verdict. So, I mean, it seems pretty extreme. But it was also, the decision was not unclear. Like, they made their decision very clear. This is what has to be done if this is going to be considered a verdict for purposes of applying it, including in situations like double jeopardy. So then the second case that I saw where this came up was from 1982. This was a Court of Appeals decision, and it was a similar type of situation. The case had gone through trial, goes to the jury reaches a verdict, they sign the verdict slip, they go home for the night, and then the next morning, one of the jurors is sick, so they get removed. And typically, when a juror is removed, they get replaced by the alternate, and you have to start the deliberation process over. You don't get to just like pick up where you left off, because this new juror wasn't part of that original deliberating jury. So might be faster to bring them up to speed as just a practical matter, but technically speaking, they have to start over with the deliberations. So in that particular case, the judge had accepted, once again, the verdict that had been signed, sealed, but just not attested to by every single one of the jurors. And once again, that was reversed. And the court said affirmation in only court is the only evidence the court can receive of the free and unanimous assent of the jury to the verdict. So again, it's a pretty unequivocal statement there that the verdict form is the evidence and the only evidence. The verdict form being completed, being submitted to the court, and being affirmed by the jurors in open court. That's all that they can rely on to establish an acquittal in Massachusetts. That's going to be a problem for Karen Reed. It's going to be a problem because, that's the whole point. They don't have that. That's the whole point. So it's not good law on their side at all. It's a situation where I think factually it's very sympathetic. It's very sympathetic. Like, yes, these are lay people that serve on the jury. They don't know the ins and outs of the legal requirements. They aren't typically going to have the type of, experience or expertise or just whatever, to parse the jury instructions. If somebody doesn't understand the jury instructions, who's the authority to, to be able to sort it out and explain it to them? It's a situation where part of the legal fiction is that, that jurors always follow the instructions, unless you hear otherwise, which apparently in Massachusetts we're not allowed to do. But the presumption is that the jurors follow the instructions. And it really is a legal fiction because it doesn't seem realistic. It's the expectation that jurors would be going into the jury room, looking at the instructions, looking at the evidence, and bringing a lawyer's mind to it. But the whole point is that they don't have lawyers' minds, and, unless they happen to be lawyers, in which case they, tend to get stricken from the jury. Well, it's not a rule or anything, it just tends to happen. But there's this expectation that they're going to have that same kind of approach, that same kind of skill set, that same mindset, that same attitude, to be able to carry out that responsibility. And just from a practical standpoint, personally, I really don't think that that's realistic. So that's kind of the standpoint of where we're at right now. So what's going to happen? What's going to happen with this motion? What's going to happen today? I don't think we're going to hear any evidence. Don't think that that's likely. It's possible. I'm not going to say it's impossible, but it's not going to be because Judge Bev is going to grant the motion. So first off, I don't think she's going to grant the motion. She may or may not rule today from the bench. Typically with motions like this, they don't. And part of the reason why is because everybody knows, I'm pretty sure, everybody knows this is appellate positioning. Nobody expects Judge Bev to grant this motion. The law is not on their side. The law isn't on their side. And so for them to be able to make something out of this, they're going to be in a position where they need to go to a higher court and argue this law is wrong. Here's why this law is wrong. And here's why these prior decisions, you need to not follow those. You need to depart from those considerations. Those are not easy arguments to make, but they do get made. They're not frivolous at all. That's how laws get changed and things get overturned, is because you make arguments that it was wrongly decided. So Judge Bev does not have the authority, the stature as a, lowly superior court judge to be making law on that kind of level, to be making a decision that higher courts, should follow different guidelines. They should reject old rules and things like that. Her job is to apply the law as it is given to her. And that's pretty clearly going to lead to a decision in favor of the Commonwealth here. But everybody knows this is being positioned for appeal. And so when a decision like this is being positioned for appeal, very common to go ahead and not rule on it from the bench. We're going to rule on it in writing, simply so that we can dot all of the I's and cross all of the T's. The judge doesn't want to be reversed. She wants her decision to be affirmed. So she doesn't want to shoot from the hip and, say something that maybe isn't correct, that could then be attacked and be used to undermine her reasoning or something like that. She wants to make sure everything is lined up as well as possible. And so you typically do that by putting your decision in writing, citing the authorities that you're relying on, and so forth. I expect that in this case. Obviously not a guarantee that that's going to happen, but that's what I would expect. So probably what's going to happen, we're going to hear argument. I don't think we're going to hear evidence. Now, again, it is possible. And the reason why I say it's possible, again, it just goes back to this positioning for appeal issue. An appellate court is going to be looking at the record of what happened that justified her decision. And so if she has made a decision that certain evidence is inadmissible, or I can't rely on it, or whatever, and you want to challenge that, you still need to get that evidence in front of the appellate court so that they know what it is. Basically, your equivalent of having an offer of proof. This is what they would say if they got on the stand, because otherwise you don't really have any way to show the appellate court why she was wrong, or what the effect of a different decision would have been. So it is, I would say, there's a tiny possibility that she could let them put evidence on just for purposes of making their record. But I don't think that that's likely. I think in all probability, she's going to conclude, the juror's testimony isn't admissible, so I'm not going to consider it, not going to hear any more of it. There is already a basis in the record in the form of the affidavits. The affidavits have been filed. The defense can, submit those up to the Court of Appeals if they're going to challenge this at some point. And there's not a need for anything else to be added into the record. So I think it's largely just going to be legal argument. She might have some questions. What I'm particularly interested in is the attitude. I'm interested in the attitude. I want to see how she takes this. Part of the reason I don't want to say, I definitely don't, because I don't believe. I don't want to say this motion was brought by the defense solely for PR purposes, right? I don't think that that's the case. When you have information like this that just, walks into your office as an attorney, you really kind of have to use it. Like you can't just pretend it didn't happen. You can't pretend they didn't tell you. You have to. That's part of being a vigorous advocate for your client is using the information that potentially benefits your position. And this is a situation where, again, factually, it seems kind of sympathetic. Maybe not as much as some of these other cases where they've said, no go. She doesn't have quite as good of facts as those cases. But they have to try, because it does, I think, strike a lot of people, just on a gut reaction kind of level that, well, this is unfair. It's unfair. If they had decided there's no way we're gonna convict her of second degree murder, she's not guilty of that, then to be able to retry her on that charge, yeah, I mean, I think a lot of people can understand why that seems like a benefit that is being given to the Commonwealth that maybe shouldn't. So I don't think that they're doing it just for PR. Again, I think this is likely done for appellate purposes. They're setting it up so that they have an argument if they go to trial again and she gets convicted, that they'll be able to go back to the Court of Appeals and say, hey, she never should have been retried in the first place, at least on these specific charges, because the jury had acquitted her. But that being said, we know what Judge Bev's perception of the defense has been, and what she's even been willing to say in open court to their faces about her perception of their handling of the case. So that's what I'm interested in is this going to be chill? Are we going to be chill in this court? Or is this going to get ugly? Or is there going to be like reprimanding going on? Is there going to be like personal beefs kind of stuff coming out? I gotta think she's going to try to keep it cool, if only because you don't want to add to the defense's argument that you're really biased. You maybe should consider getting off of this case, because you've already formed these impressions of people that are then coloring how you're looking at other things that they're presenting to you. So if we're purely logical, if we're Spock-like people on the bench, then you would keep it cool, you would keep it minimal, you would hear the argument, you would thank the parties for their submissions, tell them that you will provide them with a written decision, within a matter of weeks or whenever, and call it a day. That's what you do if you're Spock. Judge Bev is not Spock. She's not Spock. So she may have questions. She may have hard questions. She may have pointed questions. She may have more questions for one side than the other side. I don't know. I don't know what we're going to get. She might be mad. I just don't know. That's what interests me, because of that intersection between what's kind of already gone on here, the efforts that were made to remove her from the case, the arguments that she's biased, what we saw during the trial in terms of just the disparate way. I gotta keep going back to that Commonwealth motion to argue that Karen Reed trying to hire an attorney was evidence of guilt. Consciousness of guilt evidence, and she complimented them on that argument. She complimented the Commonwealth on this insane, unconstitutional argument. Whereas when the defense gets kind of annoyed because the Commonwealth is misrepresenting what they said and what took place in prior court hearings, that gets chastised as, you're arguing to me, Mr. Yannetti. Make your argument to me. In other words, don't make your argument to these cameras. Make your argument to me. Oh, we've already seen all this. So that's what interests me most about this particular hearings. Are we going to see more of this pattern, or are we going to see a little bit of a course correction from Judge Bev? Little get back to the center here. You've seen the whole case now. You saw the problems. You saw the problems. You saw that the jury didn't convict. You know, this was not a slam dunk winner for the Commonwealth by any stretch of the imagination. Maybe that will have moderated her a little bit. I don't know. I just don't know. Guys, you know, the other thing that's going on that's kind of interesting, I did pay a little bit of attention to, in terms of just, I saw it, you know, I saw it go through the commentary, but nothing's been filed, nothing's been raised about it, but I am going to keep an eye open in case something does come up. And that is that, Turtle Boy has reported that Lieutenant Fanning is who was in charge of the jury. Lieutenant Fanning of the Massachusetts State Police. He's one of the supervisors. He was in that that group text exchange with Trooper Proctor, where he was talking about getting the nudes. Yeah, and so questions kind of came up about potential irregularities with that. Like, is that normal? Is that normal? Is it normal that Lieutenant Fanning would be in charge of the jury? I don't know what's normal in Massachusetts. I don't think it's normal for the state police to typically be in charge of stuff like that. Normally in a county court, superior court at the county level, it's the county law enforcement that's in charge. So they will have the bailiffs as part of their, you know, regular shift assignments. That would be the Fairfax or the Norfolk County Sheriff. Normally, that's what I would expect. That's what I would expect. So why would the state police be involved in this? It just, that is curious to me. It definitely raises my eyebrows a little bit. I don't know. It's possible that could be normal. It just seems a little strange. It's not how it's typically done in most places. So then the other piece that's involved in that is Turtle Boy has reported that it was Lieutenant Fanning whose representations to the court are what got juror number 3, juror number 4, I think it was juror number 3, dismissed from the case. This was before it went into deliberations, and this juror had been pretty openly observed by, you know, a lot of people in the courtroom to be fairly visibly not really impressed with the Commonwealth. This juror was apparently, you know, making faces and responses to the, you know, some of the law enforcement officers' testimony. Was fairly expressive in her view of what was going on and what she was seeing. So that just, you know, potentially raises another layer of concern here, because he's then potentially a witness. And if he's potentially a witness about juror activity that seemingly is not, you know, what went on in the courtroom, apparently the whole basis for this, at least as Turtle Boy is reporting it, it has something to do with the juror was seen out at a bar that night, and I don't know, was talking about the case or saying something about the case, basically not following the judge's instructions that you're not to discuss the case with anybody. You got to wait till deliberations and stuff. If he's a witness to that, it does create a little bit of a kind of conflict situation to also be the one who's in charge of the jury. It just, it's a little muddy. It's a little messy. It's a little messy. So I'm interested to see if anything comes of that, because I don't know if it will. But it is a little bit concerning to me. And I have to think that if nothing else, if this is an irregularity, if this is something that is not how they do it most of the time, that at the very least there's going to be some questions before the retrial about what are we doing here? Are we following the same rules as for everybody else? And if we are not, why not? Why would we not be doing that? So just something that is a little bit out there on the horizon. We'll see. We'll see if it goes anywhere. Guys, I see a question came in I wanted to take. Since the burden is, say, of all 12 jurors in court, is there an argument that they should be allowed to pursue that evidence if there's evidence it exists? Well, that is certainly what the defense is trying to do. I mean, they're trying to say we should be able to question the jurors, or we should be able to bring the jurors in to get at least a limited inquiry to see if it's accurate, if they did in fact all unanimously agree she's not guilty of second-degree murder. That's what they're trying to do, and yeah, the burden of conviction is 100% on the Commonwealth. There's really no question about that. The problem that they're running into here is really those two legal principles that are kind of getting in the way. That you don't get to ask the jurors about what happened in the deliberation room, and a verdict is not a verdict until it goes through those formalities. So if they can convince Judge Cannoni that unanimous agreement is enough for purposes of due process, that Massachusetts, I mean, you can make an argument, and this is what I would expect to happen on appeal. You can make an argument that the Massachusetts law requiring these formalities of a verdict, these are not constitutional because they aren't sufficient to provide the double jeopardy protection that defendants are entitled to if they are in fact unanimously acquitted by the jury. And it would not make a lot of sense if the states can just sort of define what a verdict is for purposes of double jeopardy, because that would just give them power to be able to basically legislatively do away with double jeopardy, do away with verdicts of acquittal. I mean, if the idea is that the state legislature has the power to make that determination, then they can make it go away. So that's the type of argument I think that they have to set up, and that's why they're trying to do this. That's why they want to go down this road. That's why, yeah, they want all of the jurors on record saying we agreed, because certainly they got 4 apparently, and that's good. 4 people saying, yeah, this was our unanimous agreement. That's good. But everybody saying it unanimously, that's definitely better. Definitely better, because say they give the defense what they want and the jurors come in and we have a hearing, they come in and testify. Even one of those jurors says, nope, it's not what happened. This was just preliminary. We were talking about possibilities, but we never made that final agreement. That's what Judge Bev gets to hang her hat on, to say, you know what? I found that juror credible. And based on that, I'm finding there wasn't a unanimous decision. So it is a risky thing that the defense is asking for, but they're asking for it because I think they believe what they've been told. I mean, why would they not? They believe what they've been told. They didn't go asking for it. This came to them. And so if they can get that substantiated by the rest of the jurors on the record, it puts them in a very good position from an appellate standpoint to be able to go in and argue they agreed she was not guilty. That agreement is what has legal significance, not what the state of Massachusetts says constitutes a final formalized verdict. So that's the fight they're fighting. Should they be allowed to pursue it? I mean, Yeah, it's tough. It's tough. It's tough because under Massachusetts law, no, they shouldn't. No, they shouldn't. Very, very tricky one. So it looks like, well, we got about 10 minutes. 10 minutes left before they're maybe going to go live. Oh, what else do we have going on, guys? I mean, trial's not until January. Time's already ticking. Oh, I saw that obviously there's been some development with Trooper Proctor shortly, of course, right after the non-verdict came down. The Massachusetts State Police decided to make their announcement that they were, going through the disciplinary proceeding. I'm not sure that this is new or that this is something that wasn't known because it came up in the motions in limine. Like, I'm pretty sure everybody already knew there was an IA investigation of Trooper Proctor going on. They litigated whether they were going to be able to use that at trial or not. But it was, public confirmation from Massachusetts State Police that he's going through a disciplinary process. Clearly, from my perspective anyway, in response to the high profile that this case got and how I mean, embarrassing is like the best case scenario for describing Trooper Proctor's behavior and how that reflects on the Massachusetts State Police. Embarrassing is the best case scenario. They had to deal with it. So they made that statement. He has apparently now been placed on unpaid leave, which is honestly a little bit surprising to me. I expected a little bit of a soft landing, a little golden parachute prepared for him. They'll cut him off to save themselves, but he's played the game. He's played the game for them. He's been a good bro cop for quite a few years, and it's their turn to scratch him back a little bit. So what I was expecting is a situation where he sits on paid leave while they go through this process, and he's represented by union lawyers. They go and negotiate some kind of resolution with Massachusetts State Police where he essentially would get like an early retirement or a disability retirement or something along those lines where he doesn't forfeit his pension, right? I learned quite a bit about these Massachusetts pensions through this case. And boy, public employee and pensions, like it's a whole thing. It's been a thing for decades, right? If we're talking about just threats to fiscal security and to the economy and the growing debt crisis, inflation, risks like that. Oh boy, are public sector pensions a big piece of that. And in Massachusetts, these police officers, they are entitled to their retirement after 20 years in service. They get a pension. The pension is based on, a percentage of their earnings during their final years in service. And so it's a whole system that's worked out where, those last couple years, you take the overtime, you take the tough assignments that get, hazard pay, stuff like that. You just blow up your pay rate as much as you possibly can, because then your pension is going to be a percentage of that. And this is a lot of money. This could be a lot of money. And Brian Albert's pension, from what I saw, is, in the ballpark of 100 grand a year for doing nothing, for having been a cop for 20 years and now currently doing nothing. Yikes. So that's the kind of thing that I expected, was that he was going to get a little scratch on his back, little reward like that. But at least at this point and at this phase, they have gone ahead and at least they're not giving him a paid vacation, while they decide if they're going to fire him or not. So I guess that's something Small little almost justice kind of thing happening in this case. Anyway, the reason why I went down this Trooper Proctor tangent in the first place is because I did see this morning that the Norfolk County DA's office is now sending out Brady letters about old Trooper Proctor, which is inevitable. I mean, they have to. Of course they have to. If he is subject to adverse employment action as a result of his conduct in an investigation, yeah, that goes to his credibility. That goes to his professionalism. That goes to his competency. These are impeachable issues. And so information that is potentially impeachment evidence, yeah, that's subject to Brady. They have to turn that over. So they're now notifying, defense attorneys all over the state, oh, Trooper Proctor's in your case. Yeah, you're going to need to know. You're going to need to know he's had some adverse employment consequences. So the wheels of justice grind slowly, and they may or may not grind very fine in this case. But there are at least some marginal steps in the right direction here. Got to wait and see how it all continues to unfold. Part of what intrigues me about this whole side of the case as well, this internal affairs type of thing, if we just go by the public statement that the Massachusetts State Police made, this is all just about his language. It's not the substance of what he said. It's not what it indicates about his bias, his competency, how he conducts his investigation. It was just, he used language that was inappropriate. That's what the statement seems to say. But the problem is a lot deeper than that, isn't it? The problem is a lot deeper than that. He's telling his friends, people who are not involved in this investigation, people who are not colleagues of his, who have no business whatsoever knowing anything about an ongoing investigation. He's not only telling them about the investigation, stuff that if you or I, if we submitted a public records request to Trooper Proctor, to the Massachusetts State Police that day, right? November 30th of 2021, the day after this accident. You think they're going to tell us anything at all? Oh no. Oh no, this is not public information. This is exempt from disclosure because it's part of an ongoing investigation. Could potentially jeopardize the investigation to release that information prematurely. It's not public, but he's telling all his friends about it. And not just he's telling his friends about the investigation. He is telling his friends about Karen Reed's personal, private, medical information. Some of the most protected information that there is in courts, in investigations. So deeply personal and intrusive for that to come out. But it's about his words. It's about his words. It better not just be about his words. Okay? It better not just be about his words. Because if it's just about his words, they're not solving anything over there. I mean, maybe this is me being naive, right? Thinking that they might actually be trying to fix something there. If not, let's not go crazy. I'm not going to say they're going to do this because, they actually think it's the right thing to do. But, because the perception needs to be addressed that this agency is out of control and corrupt, and this type of thing absolutely should not be happening. Yeah, that is going to be an issue. It looks like I'm going to try to get us up here. Court TV seems to be live. So let me see if I can go ahead and get that shared. I don't think anything is happening yet. It seems to still be quiet, but we do have action at least going on in the courtroom. So yeah, so anyway, I'm interested to see how much the public ultimately does get to learn about this process with Michael Proctor. What exactly are you looking at? What exactly is your concern? If you sanction him, what exactly is the basis for that? I think it's highly unlikely that we're going to find any of this out through the media. Like the Massachusetts State Police, are they gonna tell us those details? No, I seriously doubt it. They're happy with what they've done with their statement that, you know, we've slapped Michael Proctor on the wrist because he embarrassed us, and so he's going to go through an internal process. That to them, I think, was probably adequate. Might get something from a source, you know, but I think it's more likely that we're going to hear about it once again when we come back for retrial in this case, because we're going to be revisiting a lot of these motions in limine based on new information, based on what came out in the first trial, or in the case of Michael Proctor, based on things that have developed since the first trial. So I think there's a very good chance that we'll find stuff like that out once we get closer to trial here.
All parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within Fuller County and Norfolk, Rodney, and defendant shall be heard. I'll say the Commonwealth is to the court and the seat of court now set.
Judge 22117, the Commonwealth versus Karen Reed. So identify yourself, starting with the Commonwealth.
Good afternoon, Mrs. Manley. Good afternoon, Your Honor. Laura Butler. Good afternoon, Mr. Butler.
Good afternoon, Your Honor. Robert Weinberg on behalf of Karen Reed, who sits to my left, and her counsel, David.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Jennings. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you on your motion.
Thank you, Your Honor. May I use the podium?
Of course.
Thank you.
The sound seems to be pretty bad, guys.
Judge, there are two central issues.
Don't know if there's a microphone there.
There is not one for amplification, there is one for
If
recording.
I could actually keep your voice up and turn on the information.
Yes, Your Honor.
I just want to make sure I hear it.
At a day like this, I'll keep my voice up.
Okay.
And thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, you know, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally in the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and the lesser included the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such a historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well.
Yep.
And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct, 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury? And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. And the second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend that the voicemail left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, said essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case, and I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity, that the public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not, represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel.
It's a pretty good point.
We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's action.
There we go.
Bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and the procedures in court to inform sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burdens being on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area,
Way to drop the appeals court.
Incentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice, and it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Map v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8th? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Tsarnaev that was arrested in Sudan. And they recently, in a lengthy opinion of over 100 pages, said, bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in the case dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485-90, said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit, and if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, did the jurors access the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can attest that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. But why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision, We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate, or alternatively authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed on counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. And Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure the media would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCulloch, consistent with Tsarnaev, consistent with the Supreme Court decision in Remmer, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial.
They won't.
If they were convinced by these jurors, under oath, to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal and its implications.
We know Lally will not do that.
In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here, at minimum, with 4 or 5 jurors saying, we believed her to be innocent, and we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. And this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass. 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nichols decision because it's the one that was not referenced yet for your Honor's consideration. Nichols was an interesting case. It was a driving case, jury of 6. There was a belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that there was in fact a rule of criminal procedure, and the defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser includeds. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the juror, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we had 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just 1. So the Supreme Court not only puts the heavy burden on the prosecutor, but provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And, quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of, Your Honor, taking argument from counsel regarding first the morning note, and the prosecutor didn't want a 2E instruction. The defense counsel did. Your Honor elected to give a 2E instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. You know, again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate to succeed in reversing the judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, in Nicole, the Appeals Court in a case, Commonwealth versus Oregon, that we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised your judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria, a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy, Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. If Ms. Reed was acquitted, bring the jurors and the judge, hear from them. Beg you, it's the right thing to do. Thank you very much.
Great, thank you.
Well, that was outstanding. We'll talk some more about that after we endure Mr. Lally here.
Your Honor, Commonwealth would ask, request that the defendant's motion to dismiss be denied, as it was not a verdict return.
Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and then mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel was asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts requiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when one did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, in case law, has repeatedly stated is the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries.
Oh, come on, Court TV.
Does quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. There's a reason for that, because there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point, and as the court is well aware, that's the case in which, following jury deliberations and the defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked, that does not, the not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far, it states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is in contravention to that case law, in juvenile, in Bluford, in Roth, in Gray, in all of the cases over the decades and the centuries dealing with this. Bluford itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carnes as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave that stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to record that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was charged, neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was doing, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to them, which Commonwealth would submit, were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they referred to the charges in the plurality, twice within that note, as it pertains to exactly what they were studying. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt, just looking at the affidavit from the one juror in regard to the impoundment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, and these are Mr. Yannetti's own words, on both occasions, indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote-unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for this trial at those particular points, or at least leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states, counsel's request for Arturo Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity and heard on possible alternatives to mistrial. Commonwealth versus Pereira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest, and I would direct the court to the verdict argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of a manifest necessity is a deadlock jury or a hung jury, and that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Yannetti during his arguments for the two Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Blueprint decision from the United States Supreme Court to the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those how the jury stands, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included, or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a hold. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe, as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is the court should have told or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know that there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive holdings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, in a very deliberately, as far as the language that was used, declared themselves to be on an impasse on 3 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mystery. And that is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The two areas that counsel is talking about and sort of asking for an extension of the creation of new law, again, sort of special or deferential treatment to this case or this defendant. The two areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes. Or, in an instance,
Yeah, sorry, you forgot his point.
And in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror calls you, it still does not allow the counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, and I'll sort of condense quote from Commonwealth versus Law. In the state simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlock jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury of their peers or retry them for the same thing. That's not what's happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of misconduct, and the court did absolutely nothing wrong in finding a manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
May I reply, please? Thank you.
Good old conclusory Lally. He just told you how it's permitted by the rules, and Lally's like, but it's not permitted by the rules,
Two
period.
cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, "We deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. two separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts." Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser includeds. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law, because they hadn't decided, just what they needed to decide all the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two decisions, two general verdicts, but we're in an impasse on a third one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Samayev case, where they've had just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, and the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Lally's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Toohey and Mr. Yannetti saying, well, they're deadlocked, if he wanted a mistrial, he could have asked for a mistrial then. Your Honor would have, of course, had the discretion to deny it after 4 to 5 days of deliberation. He asked for a Toohey instruction. And it's inferred by a Toohey or a Rodriguez instruction in the state court. Toohey is, I think it's a 19th century federal case, is that you have hope when you're asking for the Toohey instruction. My experience, usually the prosecutor is confident in the jury that wants the Toohey instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Toohey instruction, reflecting that he wanted further deliberations. And so it's no answer, and the Ray case does not say that when you ask for a Toohey instruction, you are really asking for something more than a Toohey instruction. Toohey means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read an internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12, when she's already convinced the first 12. Thank you, Judge.
Thank you. Any response, Mr. Lally, or you all set?
What, he gets a sir reply?
Thank you very much. I'll take this under advisement.
Thanks, Judge.
Yep, that's what we knew was going to happen. She would not rule from the bench.
Sure, thank you.
Football rise.
Well, that was quite a thing to watch, I have to say. I am so impressed by Mr. Weinberg. What a lawyer. Pretty sure nothing else is going to happen here, but of course we've got caught slipping a couple times with that, so I'll just make sure that the feed goes down before I take it off. But wow, that was an excellent argument. There's a couple of things that he did that I thought were just fantastic. The number one thing that I think was absolutely critical that he did so effectively is he shifted the perspective from the state law up to the federal, because the federal courts are the ultimate decision makers on questions of federal constitutional law, which of course the double jeopardy clause is. And so it allowed him to make some arguments that undermine a lot of the potential problems with just the posture of this case and what's going on and what they're asking her to do. Specifically, the whole thing that we were talking about at the lead up about how Massachusetts law is so strict about what constitutes a formal verdict. And so he's able to shift the attention away from that to these federal standards that make it much less clear that is going to be kind of what drives the outcome here. That it's a matter of substance, not form. You should not elevate the form over the substance, as he quoted. So that is outstanding, and that's a very good reminder, because something that Judge Bev is going to know, okay, is that there is always an avenue for a criminal case to end up in federal court. It's not a quick path, but it can get there. And so typically the way that works is through the federal habeas process, right? If Karen Reed goes, Judge, let's just take the hypothetical. Judge Bev denies this motion. Karen Reed is retried. Karen Reed is convicted of either count 1 or count 3. She appeals that. She argues this double jeopardy issue. The Massachusetts courts are going to look at this primarily, under Massachusetts law. And so they aren't going to, break any new ground as far as federal constitutional requirements for double jeopardy. They're far more likely to just look at, well, what have our courts already decided in this type of context, and apply Massachusetts standards and kind of decide it that way. Once her appeal is exhausted, however, in the state court, she can then go to federal court and petition for writ of habeas corpus and argue one of the grounds for being able to argue habeas corpus is a double jeopardy violation. So the door is going to be open there for her to be able to go into federal court and say, hey, federal court, problem here is the Massachusetts court is applying form over substance, just like you said that they weren't supposed to do, because they're saying you have all these specific requirements that have to be met to have a final jury verdict. But we have sworn affidavits here that there were, final unanimous agreements on these other counts. So Bev is going to know that, and that hint of just that process lurking down the road, that she's going to be aware of, judges who aren't necessarily, versed in criminal law or have the background in criminal law aren't necessarily going to be thinking along those lines, but Judge Bev certainly will. So I really, really like how he did that, because it takes the security of what looks like really strong state law in favor of the Commonwealth, and it really undermines it. It reminds her the state is not the final authority on these issues as it affects double jeopardy. So I loved that. The other thing that he did that I was extremely impressed with, I really, really liked, is the point that what he's asking for in this inquiry is nothing more than the court already has the authority to do under Rule 27B. This was genius, honestly. This was great, because yes, I'm struggling with this problem of you don't get to impeach the jury verdict. You don't get to inquire into the substance of deliberations, and the distinction that, well, this isn't really the substance of deliberations; it's the outcome of deliberations. Like, yeah, okay. I can kind of see that making some sense, but it's a pretty fine distinction, and so being able to cast it in that framework of, look, it's clear the rules would not allow the judge to bring the jurors in and ask them, well, what is it exactly that you're disagreeing about? Or maybe we can help you sort that out. No, that's getting into the substance, but the rules clearly do allow inquiry into partial verdicts. Have you been able to reach a verdict on any part of this case? And so drawing that analogy, that to me is extremely strong. And that was something that Lally never responded to. What are the signs of a good lawyer, especially a good, Mr. Weinberg is an appellate lawyer. We're not in an appellate context, but these types of motions are a lot more like appeal practice than the trial is. And, so something he was able to do very effectively that Mr. Lally was not and really has never been able to do, as far as I've been able to tell throughout the course of this case, is respond to the arguments that were just made by the other side. So Mr. Weinberg gives a very strong presentation. Mr. Lally did not respond to his presentation. Mr. Lally just delivered the points that he had already, written out and had planned to make. So that was something that, was very, very impressive from Mr. Weinberg. Just his felicity, his understanding of the case law, his familiarity with the case law, being able to jump on instantly what Mr. Lally was saying the case law said and point out to the judge, no, it's not what it says. It's not the context. Here's why it's different. So now, Mr. Lally, I always feel like if anybody can snatch defeat from the jaws of victory, it's probably this guy, because he's just in such a strong legal position, but did not, from my perspective, really make the most of that. I think the strongest point that he did make, which is I think a very good point, is that when you go back into that situation, we put ourselves back to when the jury is telling us we're deadlocked, we can't reach a decision, we have different views, etc. That to probe too deeply into that runs the risk of now being coercive, that you're putting pressure on the jury to suggest that, well, these are differences that can be resolved, they should be resolved, whoever is holding up the show should, get over it and go along with what the majority of the people on the jury think, so that we can get this done. That is always the primary concern during the deliberations when questions come up, or when there's a suggestion that they're not able to get there on something. The judge has to be extremely careful not to put their finger on the scale. And so we talked about that a lot when this was happening, when it was going down. And that is it's a good point. It's a good point, because if you put yourself back in that position, it's one thing to look back now with the benefit of hindsight, and appellate courts are very reluctant to second guess trial judge decisions based on hindsight, because that's not realistic. That's not the situation as it was presented at the time. And so at the time, is it fair to assume there could have been some concern about jury coercion if we went too far into asking questions about what was going on back there? Yeah, that is a legit concern. It is a legit concern. So I do think that was a good point that he made. But otherwise, I didn't really feel like he particularly drove home so much of the advantage that he has, again, just from the legal standpoint. So something that Mr. Weinberg did that sounds good kind of from the outside, but when you dig a little bit closer, like it's not actually a really very strong point. He brought up the Dzhokhar-Tsarnaev case, the one in federal court, the Boston Marathon bomber. He brought up Alec Murdaugh case, and these are both instances, high profile, well-known instances where, jurors were brought in and they were asked questions about certain aspects of, what happened during the jury deliberations. The problem with that is that neither of those are subject to Massachusetts state law, right? Alex Murdaugh, he's down in South Carolina. They're going to have their own standard. They're entitled to have their own standard. There's no constitutional right to talk to jurors, or to ask certain questions or anything like that. So they have every right to have a different standard potentially than Massachusetts does. With the Dzhokhar-Tsarnaev case, it's a little bit different because, that is from Boston, right? That is from Massachusetts. And he was prosecuted in federal court, convicted, sentenced to death. And what had happened in that case, I actually was looking at that because it was relevant to what was going on in Brian Kohberger's case when they were arguing about the change of venue and the jury surveys and whether all that was going to be allowed to go forward and so forth. What had happened in the Dzhokhar-Tsarnaev case was basically some question about media exposure and whether jurors had been exposed to certain, reports of things in the media that they weren't supposed to. And so they went through this process of bringing them in, having colloquies, asking them questions about, what they had been exposed to. If they had been exposed to it, were they able to still be fair and impartial? The reason why it caught my attention in the Kohberger case is because we had heard all kinds of great evidence during this hearing from the guy who conducted the survey about decision making and about disclosure of just bias, the extent to which bias is even known to the individual that's being asked to report it. And he was talking very specifically about how this idea that you can just suggest to a juror, you know, or just take on face value the answer to "can you be fair" and call that good. From a psychological standpoint, it's really a fiction. It's not sound at all. But the U.S. Supreme Court in the Tsarnaev case said it's enough. From a legal standpoint, that's enough. If the jurors say they can be fair and impartial, then there's no showing that they were tainted by press that they weren't supposed to see. And that's pretty much that. That is the fiction that courts rely on in that situation. So it's a good case to rely on because kind of from a superficial standpoint, it sounds like, well, it's from Massachusetts. It was, it happened there. It's in the federal court that's going to be looking at this same situation. If Karen Reed's case makes it up, through the federal courts, through the habeas process. So we should be paying attention to what they have to say. But again, there's a distinction because this was in federal court. And so federal court and state court can and often do have different standards for what can be considered as evidence. And that's really what this is boiling down to, is the admissibility of juror testimony about, whatever, XYZ as evidence in court. And so the way that typically works in federal court, they're required to apply the substantive law of the state where they sit. And so the substantive law is going to be things like the definition of the crime, the elements of the crime, probably who bears the burden of proof on those elements, that type of thing. But the federal courts can apply their own procedural rules. There can be different procedural rules in state and federal court, and the federal courts get to apply their own procedural rules. And the case law is very clear that evidence rules, they are procedural. They are not substantive. So it could very well be a situation where, once again, we have a different standard for the admissibility of juror testimony in federal court than we potentially do in state court. So it was a thing that he did that I liked because I think it's very clever, and I think it intuitively makes a lot of sense. It's good to point out to the court that what I'm asking you to do is not unprecedented. Here's these other high profile cases where it's happened. That's good argument. And Lally certainly does not have the felicity to be able to respond to that on his feed and, point out like, here's the problem with that. Here's why that's distinguishable. Here's why we can't necessarily draw any inference from the federal court doing it in that situation as opposed to what you're being asked to do here in state court in Norfolk County. But nevertheless, it has a very, persuasive effect. So I did think that was very clever and a good kind of out maneuvering, out positioning of Mr. Lally on that one. We knew, of course, Mr. Lally is not going to say, yes, we agree. If the jurors unanimously thought she was not guilty, then in the interests of justice, we should not go forward on those counts. Yeah, I like that he put it out there and he put that pressure on. But of course, that was never going to happen. That is a situation that I think is a little bit more of a political maneuver, for lack of a better way to put it, than a legal one. He doesn't have an obligation to dismiss. The argument is that he should. If you're a decent prosecutor, if you care about justice, if you care about the public's perception of the integrity of what you're doing here in this court, that's what you should do. But that's just persuasive. That's not binding. And Mr. Lally has, frankly, already shown himself to not necessarily be all that persuaded by notions of what is fair and what is right. So Judge Bev taking it under advisement, meaning we'll get the written decision some point down the road. Who knows when, couple weeks, few weeks, couple months. It's not necessarily any rush, you know? Trial's not till January. Could take a long time. We'll just kind of have to wait and see. So let's take a look at some of your comments here, guys. Marcelo Frias, nice to see you. Andrea, nice to see you guys too. I wonder how her behavior will be to this new lawyer. He is well known in Massachusetts, apparently. I already lost faith in Bev to do the right thing, even back from the pretrial motions. Well, she did play it cool, didn't she? No intervention at all. No questions, no comments, no nothing. But that chin jut look, yeah, that wasn't real favorable for the defense. I mean, she should be impressed by this guy. He's extremely impressive. I can't really reiterate how well this was argued. I mean, he's taken an issue that, I mean, 95% of the time it's dead in the water. It's a dead loser. It's not going anywhere. And he was able to argue it in a way that kind of makes it seem like maybe it's a lot more on his side than your first impression. Very, very effective. So I am sure that, you know, yeah, she knows this guy. She probably respects this guy in a different context. Maybe she would like what he has to say and rely on it or something like that. So no, she wasn't rude to him or anything like that. She didn't impute, I would hope, you know, at least not in terms of her behavior. She didn't impute what she clearly dislikes about Karen Reed's defense team to this particular lawyer. She certainly at least didn't accuse him of making his argument just for the cameras, right? But she played it safe. You know, you're not going to see that expression, that chin jut, that little smirk. You're not going to see those things on the court transcript. So, you know, if it goes up on appeal or, you know, arguments to bias, that stuff we were talking about at the beginning, not really going to be a record for it, because you're not going to see any of that. She kept her mouth shut, played it cool. From her perspective, that's the smart thing to do. That was absolutely the smartest thing to do. So, yeah, he made a very good argument. Now, did it affect her? You know, did it affect her thinking? I'm skeptical. You know, I'm doubtful. It's attorneys will argue all over the place about how much oral argument really affects the outcome anyway. The judges come in, they've already read the briefs. They've already looked at the law. They've already formed their impression of where they think the case is going. And so, in my view, it's going to be a very, very rare case where you're going to be able to come up with something in oral argument that's a game changer, that's going to be able to shift them over to a different way of thinking, because you're not bringing anything new to the table. You don't go to oral argument with new cases or new facts or anything like that. You're just there to elaborate on what you've already been able to present, to fill in some more of the details, to show the logical connection, stuff like that. So if the judge has already gone through the analytical process of thinking about what are you asking for and, you know, what do the rules say about that, then it's just, how are you able to reframe that or repitch that in a way that's going to substantially change that? I tend to think that oral argument really doesn't move the needle very much. Some people might argue with me. And I wouldn't, of course, make that a universal. Like, I'm sure sometimes it has happened that a judge changed their mind during oral argument, but just frankly, I think that that's probably pretty rare. So, don't think that she, probably changed her mind from wherever she was sitting when she came into this hearing. And I tend to suspect she was sitting on the side of the Commonwealth. But, she did him the courtesy of at least showing him respect, hearing him out. What was with inviting the sir reply from Lally? Boy, she just can't not try to give them every advantage. It's just a little bit crazy. But at least he didn't take it, so... yeah, we'll have to see what she has to say. James Casatelli, I think if she grants this motion, it would be a travesty of justice. It's opening the door to change verdicts after the fact. The jury should have just filled out the verdict form. They failed here. I definitely see this perspective. There is a reason for all of these rules. And the main one about, not being able to go back and talk to the jury about stuff after the fact is because, say you had holdouts or you had, some minority jurors, and they grudgingly reached a consensus verdict that they assented to in court, and it was handed down. But now they can come back after the fact and say, actually, that wasn't really what I thought. That wasn't really my decision. I really wasn't unanimous about that. I was just feeling pressured. You could have a situation where the jury is completely unanimous. They think it's straightforward, and then some Goomba shows up, on their doorstep, leaves a little wrapped up fish on their or a horse's head or something, and are you sure? Are you sure that's what you thought your verdict was? Kind of situation. Make the juror a little offer they can't refuse about changing their verdict. It does. There's just a lot of bad incentives that you create if you open that door to look past what the jury does in its formal actions and get into the hows and the workings behind that. So I definitely do understand this. I do think the law is pretty strongly against her, but I just keep coming back to those points that Mr. Weinberg made that I think they were really strong, that there is nothing here that's beyond what Rule 27B already allows her to do in terms of determining what the actual verdicts are. And the language from the federal case law on double jeopardy that indicates that you have to look at the substance of a verdict and not just did it meet certain formal requirements. So this is a tough situation. I mean, I agree in a perfect world, they should have done that. Absolutely. They should have done that. They should have checked not guilty on count 1. They should have checked not guilty on count 3. I can see the argument that he made that the instructions are a little bit ambivalent about, do you do that or are you not allowed to do that? Do you have to decide on all to decide on any? I think the challenge with that argument, though, is they didn't express any confusion about it. If they had come back with a question or if they had indicated it's not entirely clear to us what this means, then they'd be in a much stronger position, to be able to make that argument. But without any kind of expression like that, it's just a lot harder to say. The other thing this reminds me too that Mr. Weinberg did that I loved, I thought was so effective, is he was so good at avoiding arguing that Judge Bev made a mistake. He put it all on the Commonwealth. He put it all on the Commonwealth and how it's their burden to establish the manifest necessity that justifies a mistrial. That was so good. That was so good because obviously any judge who's being asked to kind of reverse themselves on a decision they made, they're going to naturally be a little bit defensive about that. You know, they think they made the right decision. They want to believe they made the right decision. And so you gotta make a pretty darn overwhelmingly compelling case that they didn't make the right decision if you want them to acknowledge, yes, okay, I messed up. This was my bad. And now we have to fix it. And so he avoided that whole problem so effectively, I thought, by shifting it onto the Commonwealth. You know, Judge, you only are able to work with the tools that you're given. You're not there to be some omniscient overseer of the trial process. You're there to call the balls and strikes and to sort through the arguments that are presented to you by the parties. And so if the parties don't do their job at presenting you with the tools that you need to be able to make the right decision, it's not necessarily your fault. It's on them. It's on them because it was their burden. Oh my goodness, that was good. Really, really strong advocacy with that. La Kong Express. Why didn't the letter from the jury express what they agreed on? P.S. Free Zechariah Anderson, mailboxes, mailboxes, mailboxes. Yeah, I mean, we'd love to know, right? We'd love to know. Did it just express that were they just expressing that they couldn't reach a universal decision when they went into all this flowery language about, fundamental differences, and some of us firmly believe this and some of us firmly believe, the Commonwealth's met its burden and stuff like that. Did they say it that way just because they meant we couldn't reach agreement on everything? Is it something? Is it the foreperson? Okay, the foreperson is a little bit of a moving piece in all of this, because the foreperson's the one who gets to be in charge of having these communications, right? And to speak for the jury. But the foreperson's also somebody with a vote. And so if it's a situation where the foreperson is kind of being asked to speak for a position that is not their position, the position of the jurors that disagree with the foreperson, do we think that could affect how the foreperson exactly expresses that? Oh, I certainly do. I certainly do. They can signal in the way that they answer, the way that they ask their question, they can signal kind of what they think about it, So certainly not saying that's what's happened, but just in terms of a possibility of what happened, is it possible that the foreperson was a vote to convict and so didn't want to open that door in how this got expressed? Yeah, it's possible. We'll never know if it did because we're not allowed to ask. Not allowed to ask the foreperson, by the way, what was your vote when you asked this question? But that's the $1 million question. It really is. Why didn't this get caught sooner? If this is in fact what the situation was, why didn't it get caught sooner? I mean, we could ask the same thing about why didn't when she declared the mistrial, why didn't any of the jurors speak up? Why didn't they say, hey, we found her not guilty of count 1, by the way, And it's just because this is, I guess, every case is unique. like Mr. Weinberg was saying. Frankly, Mr. Lally said it too. Every case is unique, and so it's always difficult to be looking back from hindsight and not letting that distort your perspective of how things looked at the time. And it's true. I think Mr. Lally has a good point that how it looked at the time is that there was no indication that there was partial agreement on anything. The both of the notes that the jurors sent back just really gave no indications. It just said they were deadlocked, you know, didn't say, well, we've been able to agree on some stuff, anything that might have just triggered, raised a question, you know, hey, maybe we should inquire into this a little further. Maybe we should poll on the counts, you know, something. But it just really wasn't there. So it's unfortunate that this is how things unfolded, especially if that is in fact what the jury decided. Let me just rave a little bit more about Mr. Weinberg because I loved the point that nobody's come running forward here to contest this. Absence of evidence is not evidence of absence. We got to keep coming back to that. The fact that no juror has come forward and said that isn't true, isn't evidence that it is. But when you got 4 jurors that are they're all on the same page. They're all consistent with what they're describing. And you have 8 others out there, none of whom have gone to any effort to say that's not how it went. It's not how it went down, not what happened. Does kind of create a little inference, doesn't it? I loved how he did that. That was such a good argument. JT000, very satisfying to see a really good lawyer in action. I agree. Not talking about you, Lally. Also agree. No interruptions or touchy comments from the judge today. I do wonder if this is respect for him or if this is just figuring out that what's best for her is to not inject herself. Don't be part of the story. Don't be part of the process. Let the parties make their argument and make your decision. That's the judicial thing to do. She's fallen short on that several times throughout the course of this case. Don't know. We'll never know that either, but I agree. I enjoyed that presentation from Mr. Weinberg immensely. Extremely well done. I mean, I still don't think they're going to win, but he's done a great job at convincing me that it's a closer question than I thought it was coming in at the beginning. And that there are more pathways to get there than, you know, maybe I considered independently. I think he did a great job. That Rule 27 argument. Oh, yeah, that's right. That is essentially all he's asking her to do. That was great. And Lally had no answer for that. Just that conclusory, no, the law doesn't allow this. Why? Well, because I said so. Not because I have something to cite, because I said so. And Mr. Lally, I will just remind you, you are not authoritative. Miles Heffernan is a member now. Thank you so much for joining. Welcome. And Hoobie, someone was whispering something while Lally was talking about the verdict slip. I think it's Judge Cannoni saying we never corrected it. I would love to see. I definitely heard the whispering. Couldn't make out any of what it was. The sound was bad enough, even just trying to listen to the lawyers speaking in open court. So I could not hear the details of what she was saying. I will not be surprised at all given interest in this case, the attention, and just the mad sleuthing that's already gone on to date. I'll be interested to see if somebody tries to do some sound cleanup, a little enhancement, maybe isolate that whispering, see if it can be clarified a little bit. Because yeah, it would be interesting to hear what was going on. You never really know. It may not necessarily have anything to do about this case at all. It's somewhat common for, other things are going on in the courthouse at the same time. And often when there's interruptions like this, it's not even necessarily about this case. It's about something totally different. So, it's just who knows, but I will be interested to see if somebody goes to a little bit of effort to see if we can get more information about that. Kristen asks, was the jury in the courtroom when the mistrial declared? I thought they were still in the jury room. No, so what happened was she called the parties and she had the note at that point in time, and she told the parties, they're deadlocked. I'm declaring a mistrial. Let's bring the jury in. And that was, I'm summarizing, but that was really about the gist of what it was. There was no invitation for comment. There was no, what do we do now? There was, she didn't read the note at that time. It was nothing like that. So then they brought the jury back in. She read the note to the jury at that point in time, and she declared the mistrial then in the presence of the jury. So they were there. They would have witnessed it. But again, are they attorneys? Probably not. At least, not all of them. Maybe there was an attorney on the jury. I have no idea. We don't have any way to know. But, we know it's not 12. Highly unlikely it's 12 jurors sitting, 12 attorneys sitting there as jurors in the case. So do they necessarily know what that means? No. Are they necessarily sitting there looking for the distinction between I'm declaring a mistrial and I am declaring a mistrial as to count 2 and entering judgments of acquittal as to counts 1 and 3? No. They aren't necessarily going to be in a position where they would be aware that something is amiss. So, I brought that up really just to kind of emphasize the point that the hindsight is 2020, and it's easy to look back now and be like, oh, they should have done this, they should have done that, this should have got their attention, they should have asked this question, et cetera, et cetera. You can second guess all those decisions, until we get to the second trial. But the appellate court's always going to look at it. They're going to do their best to put themselves in the shoes of the people at the time and to judge the decisions that they made at the time. And so at the time, would the jury have necessarily been alerted, been aware, that something else should have happened here? No, probably not. Probably not. At the time, should the parties have been aware that maybe there's more than meets the eye here? Not necessarily. Really didn't have any good indication in the information that the jury had communicated to them. So overall, just a very intriguing, a troubling situation that I don't know is going to have good legal recourse. Still, I'm not there to the point where I think Judge Bev is going to be convinced about this. I think it's a situation where they're setting it up for a possible federal court that may be more receptive to the argument that, the agreement in and of itself is enough to constitute an acquittal. So not necessarily any real legal recourse for it. And it's just in that zone of error, that's tolerated. There's a massive amount of error and confusion and not quite getting it right in trials. That's tolerated as part of the process. And I just kind of think that's where we're at with this one. This is a product of jurors not necessarily being super educated about the process, independently. They're given instructions, but the instructions themselves can be confusing. They can be unclear, and I certainly criticize these ones and continue to do so in this case for just the volume of them. There's so much there, and so much of it is repetitive that, it's hard to sit and pay attention to it. They're told that her spoken instructions trump whatever's in writing on the copy that they get. So that's telling them, you have to be paying close attention to what I say and the details of what I say here in court, because that's what the rule is. And then you talk at them for like 2 hours. How is that realistic? They're just buried in this information, buried in these standards that to the trained lawyers, the experienced lawyers in the room, yeah, this stuff is second nature, but that's not who the jury is. And there's just this presumption that they're going to be able to fit into this role and adopt these mindsets and stuff that the process wants them to have, that just may not be realistic. But that's just part of the process. That's part of the fiction that jurors are able to do that. Millie Martinez. Andrea, thank you so much for your commentary. Do you know if there's any way to hear or even read the presentation from the defense today? I couldn't hear a word of it. The sound was terrible. So, I had the closed captioning on in the hopes that it would be helpful. Sometimes it is, a lot of times it's not. It clearly couldn't tell the difference between jurors and Jews. So, a few points where, it comes up with gobbledygook, but at least some of it was pretty good. So I'd suggest, you can check the transcript on Law and Crime, on Court TV, any of the places that streamed it, and see if that helps. Also, again, possibility someone might try to clean it up, try to clean up the audio and enhance it a little bit, so that we can hear a little bit better. I was really having to strain and lip read, a little bit to try to follow most of the details. But I'm with you. Even with that, there were some points that I just wasn't able to hear it. So the last possibility, yes, is somebody might order a transcript of the hearing. It's a hearing on open court in a court of record. So it is being, I didn't see if the court reporter is there doing it live, or if it's, well, if they didn't have microphones, then it's probably not being recorded for later transcription. But either way, there is some step that's being taken so that a transcript of the hearing can be prepared. So it's possible somebody could order that and release it. May not be, too expensive for a relatively short hearing. Like the trial transcripts can get massively expensive because of how long they are, but this one is relatively short. It's probably, somewhere in the 75 to 150 pages ballpark would be my, just offhand guess off the top of my head. It might not even be that long. So possible somebody could order it if one of the parties get it. It could be released. I don't know. It's not something that's like automatically done that will be filed or anything like that. So just if it comes out, I'll try to keep an eye open and see if something like that becomes available. But as far as like a default, is there going to be something like that? No. The default is going to be this terrible recording that we got, that we should apparently be thankful for the privilege of even being able to have the camera there in the courtroom in the first place, so that we could watch that go down. So I will keep my eyes open. If I see something, I'll put it up in a community note if I see something. So thanks you guys all very much for your, again, good questions and comments, for being back in chat. It's good to be back. It's good to be back. I don't know when we're going to get a decision. Like I said, I would like, everybody would like it to be soon, just because you don't want to go too down the road of trial prep if it, looks like you're not going to actually have to do it again. So possible it'll be a fairly quick turnaround, but just no real guarantee about that. I would definitely consider, if we get a decision relatively in the short term, to go ahead and just go live and go over that. Because why not? We can look at it together, see what it says, and kind of have the reactions to it and stuff. See what the reasoning is. So I'll keep my eyes open for it. And of course, as usual, if you guys see anything like that, tag me on Twitter, let me know, and just bring it to my attention, and I'll be happy to take a look. So guys, what's next? I don't have anything on the short-term horizon right now. The next thing specifically that I have scheduled for going live is the Brian Koberger hearing, the motion for change of venue. That's scheduled for August the 29th. We don't have a time yet, but I'm kind of anticipating it might be one of those like where they set aside the whole day to do it. I don't know for sure. But I'm just planning on, having the whole day available. At some point, we'll get more information about when exactly it's going to be. But absolutely, I'm going to watch that one. That's going to be a banger. So we got the motion from the defense, their survey results, and just the information that they were able to get. It is so disheartening from a standpoint of just the presumption of innocence there is none in this case. The taint from the media and the reporting and just the way this case has been pitched is really, really not good. Something like 60%, 70% of potential jurors in the county already think he's guilty, and they can't be, they will say they can't be persuaded otherwise. I mean, that's so bad. So bad. So, yeah, that's the next thing that I specifically have on the calendar coming up, August 29th. It is a little bit down the road, but there's nothing else really that I'm watching closely right now. So once again, if something comes up, I will put it out there. I will try to give you guys some advance notice. But that is pretty much what I have as far as scheduling. I see another question came in from Kristen. I know nothing about court. Why do we have to pay for transcripts? Oh, the $1 million question. Why do we have to pay for any of it? Why do we have to pay for any of it? I could go on a long rant here about the fiction that the law is publicly accessible. Because, of course, if you want to be able to find anything meaningful in the law, you're always going to have to pay for it. You're going to have to pay to get access to a database like LexisNexis or Westlaw or somebody like that that publishes this information, that organizes it in a way that's searchable. You're always going to have to pay for copies of documents from the court. You're often at the mercy of the courts to charge exorbitant prices to be able to get things from the public record, the records of the process that are supposed to belong to us. And part of the reason why is because that's, in some measure, how courts fund themselves. They fund themselves through fees and charges and things like that. So that's why, because they want to be able to pay. They want to make you pay for the 5 minutes it took the clerk to pull the file and get the document out and hit print. This is like in the old days. This is before e-filing. Like everything's e-filed now, right? It takes the clerk 3/4 of a second to attach a PDF to an email and hit send. But no, they're going to charge you for it because that's historically how it's always been done. It's part of how they generate revenue for the courts. Yeah, it's terrible, and it shouldn't be the case, but that's how it is. With transcripts, there's even this extra level because in cases where you have live court transcriptionists, well, frankly, even when you don't, you still have to pay somebody to do that transcription. And the transcription is a pretty specialized skill. There's like a whole language essentially that they learn, this phonetic language that they learn to be able to take the shorthand and then, translate that and turn it into spoken English that the rest of us will understand. So that transcriptionist gets to charge for creating the transcript. When it's for appeal, for example, I will routinely, I have to, order transcripts from the court reporter who was in court for that process because there's no other way to get a record of that proceeding. When there's a live court reporter sitting there in the courtroom, then often you don't have a recording. You don't have a backup. You have that reporter and that reporter's notes, and that's it. So you're at their mercy. And yeah, they charge a lot. They charge a lot. It varies, all over the place depending on where in the country you are and stuff. And there's a lot of just complicating factors that go on. But part of the deal is that courts don't typically pay court reporters like specialists, like professionals. They pay them like, equivalent to sort of unskilled people or just, low level staff. And so then how they make their money making up that difference is by doing these transcripts. It's all allowed. It's all allowed. Why is it allowed? Great question. Great question. Is the law supposed to be public or is it not? We have this entire fiction that everybody's presumed to know the law, right? Ignorance of the law is no excuse. We know it's a fiction because we have people frankly admitting that we don't even know how many laws there are. We can't even count them. We can't even inventory all of the laws that everybody is potentially subject to. But yeah, we're presumed to know all of them. And that's, then access to it. Yeah, maybe if you're a billionaire, you could have access to all of the law in the country. But if you're not, no, then your access depends on your ability to pay for it. Two-tiered system, anyone? Yeah. So anyway, that was a little bit of a rant. Sorry about that, but that's the short answer to why do we have to pay for transcripts? Because we have to pay for everything in courts because that's how they make money. That's how the courts make money and fund themselves. So somebody at least would have to pay, typically it's the party that's ordering them. So that's what I was saying when I kind of got sidetracked. Often have to order them for appeal. In my cases, my clients are indigent, so they get paid for at public expense. But if they were not, if I'm representing a private person, yeah, you want to go forward with an appeal, you have to pay for your transcript. Just part of the process. Just part of the process. So, well, guys, that was good. That was good. I really liked that presentation. God, that guy really knocked it out of the park. Mr. Weinberg, he did so much more with that issue than I thought he was going to be able to do. Yeah. Still don't think he's going to win it, but moved the needle in my mind for sure. Definitely made it look like her position is stronger than otherwise I thought it was before we went into that hearing. So if an advocate can do that in the courtroom, that's what it's all about, isn't it? That's how effective you are, is your ability to persuade. And I think he did a fantastic job in so many ways. Excellent argument. The style in which he presented it, I thought was outstanding as well. He wasn't scripted, but he clearly knew where he was going and what he was saying. It was structured without being scripted. And that's, I think, always something that's it's just a standout, to have prepared that so well in advance, so thoroughly in advance that you understand it at the 10,000 foot level so well that then you can just speak off the cuff when it comes to kind of filling in those details. So very impressive lawyering from Mr. Weinberg. Great acquisition for Karen Reed's defense team. He's worth every penny that they are paying him. So gonna go ahead and wrap it up now, guys. Thank you so much again for being back here, for watching this with me. I did enjoy. I've been kind of watching the view count a little bit. It was pretty funny. Like as soon as Mr. Lally steps up, boom, drops. I don't blame you guys. I wasn't necessarily thrilled to hear more from him again too, but anyway, just glad to see so many of you back here, and still interested in this case. I'm definitely still interested in this case. Would prefer, of course, that we not have to watch the trial a second time, but barring something a little bit more dramatic than perhaps what we've seen so far, I think that's likely what we're going to be seeing down the road. So I'll be ready for that when it comes. In the meantime, be here August 29th, the Koberger motion to change venue. I will be here, very excited about it. And if you don't have notifications turned on, go ahead and do that. I try not to push the whole do the YouTube things, because you guys know you know how YouTube works. But just because I will, if something catches my eye or sometimes I just get inspired. I have something to say, something to think about, decide to go live or put a video out or something like that. Just have the notifications on so that you can be aware of that. And I'll catch you by surprise maybe. So in the meantime, I'm going to enjoy a little bit more of the summer here. It's almost fair season. I don't know about where you guys are. How many of you are urban? How many of you guys are rural? If you're a little bit more rural, then, you're like me. Fair season ends up being kind of a big deal. We're like almost there. It's, kind of the pinnacle of summer, the cotton candy and the livestock shows and the rodeo and all that good stuff. So looking forward to that right around the corner here. So, yeah. Thanks again for being here, everybody. Appreciate seeing you all back in the chat. Having a great time. And we'll look forward to doing it again soon. So until then, please take care, and I will see you next time.